EDC? The gentleman at DDC, what's your name, sir?
Kenneth Davis. Kenneth
What's
Dwight
your
Davis
full
Jr.
name, sir?
Kenneth Dwight Davis Jr.
Thank you, Mr. Davis. I'm Magistrate Chuck Vassar. Not only do you have 2 criminal matters, you have a misdemeanor matter. Counsel Faraj, are you representing Mr. Davis on the misdemeanor matter? Traffic.
Your Honor, I was appointed. I heard you said that was the case. I went in for.
I'm sorry, counsel. I didn't hear you said yes or no.
I'm appointed for his felony.
I didn't make out what she said.
Can you hear me now?
I can hear you. I just need to know if you're representing Mr. Davis on the traffic misdemeanor matter.
I have been appointed for felony, not his misdemeanor.
Okay, so you're not representing him on the traffic. Thank you. That's a no. Mr. Davis, I'm Magistrate Charthea. Good afternoon, sir. You're here on a misdemeanor matter, traffic. You're going to get a personal bond, no dollar amount. Ticket number is U 595-124-21. Misdemeanor, sir, it is disorderly conduct, disturbing the peace. The maximum penalty on this misdemeanor, sir, is up to 93 days jail and or $500 fine. You understand that, Mr. Davis?
Is it dismissed? I didn't understand you.
Okay, Mr. Davis, you have a misdemeanor traffic matter. Basically, it is disturbing the peace, disorderly conduct. It is from September 22nd, 2021 in the area of 2000, hold on. 2001 Finkel, City of Detroit. Do you understand that, Mr. Davis?
Okay, yes. Yes, ma'am.
Okay,
Yes,
I'm gonna
Your
enter
Honor.
plea of not guilty. Again, penalty is up to 93 days jail and or $500. I'm gonna enter plea of not guilty. Court date is May 4th, 2023, sir. It is a pre-trial in front of Judge Evans. Again, you're getting a personal bond, no dollar amount. The maximum, again, in front of Judge Evans. Sir, you have a right to remain silent. Anything you say orally or in writing. You also have right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Do you understand those rights, Mr. Davis?
Yes.
Thank you. Mr. Davis, the first case is 230-56303. Please say your full name, sir.
Kenneth Dwight Davis Jr.
Thank you, sir. Go ahead, Counsel Faraj, name, please.
Attorney
Counsel, name.
appearing on behalf of number 85175.
Counsel, you're coming in choppy.
I said, can you hear me now, Your Honor?
You're coming in low now. Are you Sahar Faraj?
Yes, Attorney Raj, on behalf of Mr. Davis.
Again, you're coming in choppy. What's your P number?
175.
85175, ma'am?
Yeah.
Thank you. You wait for my reading and stand mute.
Yes, Your Honor.
Okay, we have another case. This is case number 230-56304. People of the state of Michigan versus Kenneth Dwight Davis, also known as Kenneth Dwight Davis Jr. Mr. Davis, please say your name again.
Kenneth Dwight Davis Jr.
Okay, and Counsel Faraj, you represent Mr. Davis on this case.
We were made, can you, Your Honor, hear me better now?
I can hear you low, but you represent Mr. Davis on both matters, ma'am.
Your Honor, I've been appointed for his 2 felonies. I'm not sure what the charges are, so I don't know if for both of those cases.
Ma'am, did you have an opportunity to talk to Mr. Davis?
I have, and he was only made aware of the 1 case.
Okay, he is, I'm gonna let you know, and I'll read both cases, the charges. Is that okay? Is that all right?
We can waive a formal reading of the charges, Your Honor, and enter a plea of not guilty. That's fine.
Okay, so you have no problem, you waive formal reading on both cases, is that correct?
Yes, Your Honor.
Okay, thank you. I'm gonna enter plea of not guilty, same court dates, April 18th, 2023. It is a probable cause conference, followed by preliminary examination, April 25th, 2023. Preliminary examination is at 1:30 PM. Both cases are in front of Judge King. Mr. Davis, you have some bond conditions, sir. Please listen and raise your hand if you cannot hear me correctly. One is you are not to have contact with these. Understand that, sir?
Yes, ma'am.
Sir, when I say no contact with those individuals, I mean no person-to-person contact, no contact to third parties, no phone calls, no emails, no text messaging. Do you understand that?
Yes, ma'am.
All right. Also, sir, you are not to possess arms or any other dangerous weapons. You understand that?
Yes, ma'am.
Okay. In reference, you are not to go to the location of 128 Detroit. You understand that, sir?
Yes, ma'am.
Okay. You understand all the bond conditions, sir?
Yes, ma'am.
Okay, in both cases. All right. Counsel Farage, I'll let you go first as to bond argument. Go ahead, ma'am. On both cases.
Your Honor, before, if I may, before I make my bond argument, is there a way that an investigator's report can be sent over?
No, ma'am.
Okay, so concerning bond, we understand that the court is aware that they must make a finding of the record of all the following factors. Number one, Mr. Davis realizes the seriousness of the offenses that he's charged with, and we understand that the court must protect the public from any danger. However, those are not the only factors that a court must consider when determining bond. Mr. Davis doesn't have any recent criminal history whatsoever with either the criminal justice system or contact with the police. It's to my knowledge that when Mr. Davis was a juvenile, he never was charged with any assaultive or dangerous charges. And lastly, Mr. Davis doesn't have any history of failing to appear, and he has strong community ties with his family. Mr. Davis himself is a father of a 3-year-old that he takes care of. Mr. Davis just began recent employment at a local restaurant in his community. And lastly, Mr. Davis has suffered from a very long time from severe mental illness of schizophrenia. His primary caretaker was his mother. Unfortunately, his mother has just been taken into custody and is doing time in prison. So in her absence of care for Mr. Davis's illness has regone, severely, and it's gone untreated, and that's when these allegations have come into play at this moment in time. And based on these representations that we made, we ask that Mr. Davis be released on his personal recognizance bond, or in the alternative, due to Mr. Davis's suffering from severe schizophrenia and not getting his medication at the current facility, we ask that Mr. Davis be transferred to an inpatient mental health facility. And again, I'm appointed counsel for Mr. Davis, so Mr. Davis will have the full benefit of all NDS resources. He'll have access to client advocacy, our social work, and our entire team. So based on those representations, we ask that Mr. Davis be released on a PR bond, or in the alternative, be transferred to a mental health facility.
Thank you, counsel. APA Moore, please
Yes,
put your
good
name, P
afternoon, Your Honor.
number, and your argument on the record.
Thank you, Your Honor. My name is Elizabeth Moore. I will be the prosecutor on this case. My P number is P84724. I would like to address bond. At this time, the people are asking for a high cash bond with a GPS tether and the no contact provision that the court already reiterated to the defendant. We believe that high cash bond is appropriate for both of these cases, specifically under Michigan Court Rule 6.106B1B, which specifically addresses the fact that in the one case, the defendant is charged with criminal sexual conduct in the first degree. And per that court rule, it indicates that If the court finds proof of the defendant's guilt is evident or the presumption is great, which the circumstances of this particular case, in both cases, I do believe the presumption is great, then the court, if they're found by clear and convincing evidence that the defendant is not likely to flee or would not present a danger to another person, then they can lower the bond. However, I do believe there are considerations here that are important to note. Specifically, the fact that the defendant is charged in 2 cases for sexual assaults that have to do with one occurring on March 26th and one occurring on April 3rd. The timeline between these 2 is very, very short, indicating that the defendant presents a very clear danger to the community, especially considering the circumstances of these cases, one in which he actually committed a home invasion and committed the sexual assault at that point. And then the second one, it was just what seemed like a very random incident off the street. He poses a very clear and present danger to members of the community as a result of this. Additionally, I know that defense mentioned that he has ties to the community and that he is a father. However, it's my understanding per the interview that the Detroit Police Department conducted with the defendant that he does not have a stable home or residence to go back to at this time. So the likeliness that he would be able to return to court, that he would have a home to stay at, should he be released, is not great, indicating that he may not be able to return to court, or he may not be inclined to return to court if he does not have a stable home or residence in the meantime. The facts of both cases are significant, and as a result of all of the evidence in both cases, including admissions made by the defendant himself, I do believe that both cases are likely to move forward. I think they stand a good chance of moving through the system due to the just overwhelming evidence in these cases, and therefore a high cash bond with a GPS tether is appropriate.
Thank you, counsel. I heard both representations from APA Moore and defense counsel Farage. Okay. According to the Michigan Court Rule 6.106, pretrial release, and that would be A1B, excuse me, 6.106B, 1B, where the defendant is charged with criminal sexual conduct of first degree. And if the court finds proof that the defendant's guilt is evident or the presumption is great, unless the court finds with clear and convincing evidence that the defendant is not likely to flee or present a danger to any person. And in this case, under 1, it refers to that court may deny pretrial release. And APA Moore, are you asking for a bond?
Your Honor, I am asking if the court deny pretrial release. However, should the court be inclined to grant a bond, I just ask that it be a high cash bond with a GPS tether.
Okay, thank you. And counsel Farage, so I understand you want a bond or personal bond based on your arguments, your representations. Is that correct?
A PR bond, or in the event that Mr. Davis is held, denied pretrial release, to be transferred to a mental health facility.
Okay. Well, folks, I do believe that Mr. Davis's cases, okay, falls under 1, where the court may deny pretrial release, because not only is he charged allegedly with criminal sexual conduct first degree from July 26, 2023, but he's also charged with criminal sexual conduct third degree, which allegedly happened April 3rd, 2023, short period of time, under 1 case from March 26, 2023, allegedly that there is a DNA match, or it's consistent with Mr. Dwight's under what's called Codex. Okay. And that there is enough evidence under the second case from April 3rd, 2023. Okay. in this particular matter, I do believe that Mr. Davis, outside of his admissions in both cases, I do believe that Mr. Davis is a danger to the community in this particular matter. Do not know whether or not he is a flight risk. Okay. So for those reasons, more specifically, that I do believe that this court has the authority to deny pretrial release to Mr. Davis, because I do believe that there's clear and convincing evidence, or the presumption is great, that his guilt is evident in this particular matter. He is going to be remanded to the county jail, no bond. Okay. And folks, so you understand, with the remand, there is no unaffordable court date. Do you understand that, Ms. Farage, Counsel Farage? I just want to make sure.
What do you mean by that?
That means he does not get another opportunity to go in front of another judge before his probable cause hearing for the bond to be heard. On the remand, there is no unaffordable court date. So if bond is to be argued, again, it will be argued on April 18th in front of Judge King. Do you understand that, Counsel Farage?
Yes, Your Honor.
Okay. APA Moore, do you understand that?
Yes, Your Honor, thank you.
Okay. All right. APA Moore, do you want to add anything else for the record?
No, Your Honor, thank you.
Okay. Okay. Counsel Farage, do you want to add anything else for the record?
Yes, the discovery be sent over. If I could provide.
Okay, that'll be something that you need to go, counsel, that needs something that you need to contact Counsel Moore or go through the prosecutor's office.
I
Okay,
understand.
counsel? Okay,
understand.
no problem. Folks, have a good day. Mr. Davis, you can step aside.
Thank you.
Thank you. All right.